Welcome, everybody. May I have your attention, please? My name is Jack Goldsmith. I'm a professor at the law school, and welcome to the Herbert Vaughan Memorial Lecture. Mr. Vaughan was a 1948 graduate of the law school who practiced law with distinction for 47 years at the Boston firm of Hale and Dorr, now Wilmer Hale. Mr. Vaughan endowed this program, in his words, to promote and advance understanding of the founding principles and core doctrines of American constitutionalism. He asked that this statement be read at the beginning of each of these events. Here it goes. In my judgment, the Constitution of the United States is the greatest practical achievement of political science. It is a testament to the extraordinary gifts of creativity, prudence, and high-mindedness possessed by the founders of our nation. May you be guided and inspired by their genius as you meet the challenges of the present day. Today's Vaughan lecture, entitled The Natural Law Moment in Constitutional Theory, is by Professor Joel Alicea. Professor Alicea is an associate professor of law at the Catholic University of America's Columbus School of Law and the co-director of the law school's project on constitutional originalism and the Catholic intellectual tradition. Prior to academia, Professor Alicea practiced law at Cooper & Kirk, where he did constitutional litigation. He previously clerked for Justice Alito at the Supreme Court and Judge O'Scanlan of the Ninth Circuit. Professor Alicea's scholarship as a peer was forthcoming in the Yale Law Journal, University of Pennsylvania Law Review, the Virginia Law Review, and the Notre Dame Law Review, among other publications. I believe that Joel is the youngest Vaughan lecturer ever, which is a testament to the extraordinary importance of his work to date. And as a final note, and a comment on my capacities as an advisor to young scholars, I just want to say that Joel is a former student of mine. And when he was going on the market and thinking about his early scholarship, I said to him, he was interested in constitutional theory and constitutional interpretation. And I said to him, I really don't think that's a good place to start. It's a dangerous place to start. It's a very high bar to success. And it's just very, very difficult. And I advise you to at least split it up with some other things and maybe do that later in your career after you have tenure. And Joel utterly ignored my advice and quite successfully so. So, Joel, welcome.
Well, thank you, Jack, and thanks to all of you for coming. It's a real honor to be here to deliver the Vaughan lecture. I remember attending the Vaughan lecture when I was a student here a little over a decade ago, and so to be here at the front of the room giving this lecture is kind of surreal and as I said, a real honor. Over the last several years, we have seen an outpouring of legal scholarship on the relationship between natural law and American constitutional theory. Consider just a sample of the work produced since 2016. Jeff Pojanowski and Kevin Walsh's co-authored articles, Enduring Originalism and Recovering Classical Legal Constitutionalism. Lee Strang's book, Originalism's Promise. Mark DiGirolami's articles on traditionalism, and his forthcoming book, We Mean What We Do, The New Constitutional Traditionalism. Adrian Vermeule's book, Common Good Constitutionalism. And a few pieces of my own, The Role of Emotion in Constitutional Theory, The Moral Authority of Original Meaning, and Constitutional Theory and the Problem of Disagreement. Other scholars and works could be added to this list, but this sample should already make clear that something new is happening in American constitutional theory. Never before have so many legal scholars sought to ground constitutional theory in the natural law tradition. And if I might add, just anecdotally, that outpouring of scholarship is met by a demand for natural law constitutional theory on the part of jurists, lawyers, and law students alike, in my experience. Indeed, we can truly say that we are living through a natural law moment in constitutional theory, a period of unprecedented interest in natural law among constitutional theorists. Now, in making that claim, I use the terms constitutional theory and natural law broadly. The term constitutional theory, for instance, can refer to at least two different kinds of constitutional theories. Most commonly, disputes. And here I think Steve Sax's original law originalism is a good example of that kind of theory. I mean to encompass both understandings of constitutional theory in my remarks today, except where I make clear that I'm using a narrower meaning. Similarly, by natural law, I intend a broad meaning that includes a variety of theories and traditions that travel under that banner. Generally speaking, natural law refers to those principles and precepts that conduce to human good and are knowable through human reason. Natural law theory holds that there are objective goods, which means that there are also objective wrongs. These are understandable in light of human nature. We can identify them through reason. And unlike other moral frameworks, the natural law tradition would claim that there are some absolute moral wrongs. The tradition's most well-known thinkers include Aristotle, Cicero, and Aquinas. Now, my assertion that we're living through a natural law moment in constitutional theory immediately calls to mind three questions. First, how, if at all, are the theorists of this moment different from prior theorists who sought to ground constitutional theory in natural law? Second, what explains the rise of natural law in American constitutional theory? And third, what are the implications for constitutional theory of our natural law moment? So in my limited time today, I'd like to sketch answers to these questions with the caveat that, of course, much more could be said about this topic than I'm going to be able to cover in my time here. For example, my focus will be on the revival of interest in natural law among American constitutional theorists, but it's worth noting that there has also been a revival of interest in natural law among American legal historians. Among others, you could list Judd Campbell, Stuart Banner, Jonathan Guynap, Richard Helmholtz, many others who are exploring this topic, the relevance of natural law, the history of natural law reasoning in American law, and how that could inform constitutional theory and constitutional interpretation. So a complete analysis of our natural law moment would need to account for this parallel development that's happening in legal history, and it would need to examine the potential implications of that historical scholarship for constitutional theory. But I'll leave those intriguing lines of inquiry for another occasion. So let's start with my first question. What makes the theorists of our natural law moment distinctive, other than the fact that there are more of them now than there were in previous decades? While there are many things that could be said in response to that question, I'll limit myself to three observations. The first distinctive feature of today's natural law constitutional theorists is that they are self-consciously Thomistic in their approach to natural law. Now, anyone familiar with these debates knows that there are extensive Baroque debates about what constitutes a Thomistic theory of natural law. This can get really into the weeds and quite esoteric. I don't intend to wade into that debate here. So when I say Thomistic, I simply mean that these constitutional theorists who I'm referring to rely heavily on the work of Thomas Aquinas and purport to ground their theory in Aquinas' thought. For example, all of the scholars I mentioned at the beginning of my lecture expressly adopt Aquinas' classic definition of law: an ordinance of reason for the common good, promulgated by one who has legitimate authority. Fourfold definition. They build their constitutional theories on that understanding of what law is. But even beyond Aquinas' theory of law, these scholars, to varying degrees, rely on Thomistic arguments about the nature of political authority, the relationship between reason and emotion in the human person, and the moral obligations of jurists, lawmakers, and citizens in relation to law, among many other topics that you can find in Thomas's thought. By contrast, scholars who wrote about natural law and constitutional theory in previous decades tended not to be Thomistic in their approach. Hadley Arkes and Harry Jaffa, for example, are probably the best known scholars who consistently wrote about natural law and constitutional theory prior to our natural law moment, but their theories were quite eclectic, borrowing from and blending together arguments by figures as varied as Aristotle, John Locke, Immanuel Kant, Abraham Lincoln, and George Sutherland. For instance, Arkes' most recent book on the natural law, titled Mere Natural Law, never cites Aquinas' definition of law, and Aquinas appears on many fewer pages than Abraham Lincoln or James Wilson. Jaffa, I want to be clear, I'm not saying that Arkes and Jaffa didn't talk about Aquinas or mention him in their work. They obviously did. You can't write about natural law theory without talking about Aquinas at some point. Jaffa wrote a whole book about Aquinas' thought, but in terms of grounding their constitutional theories in Thomas's understanding of the natural law explicitly and repeatedly, that is just largely absent from both Arcus and Jaffe's work. Instead, as I said, they tended to rely on a much more eclectic blending of different theorists and traditions, not all of whom I think can be said to be Thomistic and grounding their views in Thomas. Now, this lack of a Thomistic grounding has ramifications for constitutional theory. For example, Arcus doesn't rely on Aquinas' definition of law, as I said, and because of that, he's not forced to confront whether his understanding of the judicial role is compatible with the scope of legitimate judicial authority under the American Constitution, or with the relevance of the promulgated constitutional text, two questions that you can't help but confront if you're dealing with Aquinas' definition of law, because that's two of the criteria, right? Now, my purpose here is not to litigate the merits of Arcus's or Jaffe's theories. I'm not here to criticize them. It's not to argue here that the Thomistic approach is superior to or more coherent than the way that they conceive of natural law. I'm simply pointing out that the lack of a Thomistic grounding for their views has important implications for their constitutional theories, and conversely, that the Thomistic grounding for the views of the theorists of our current natural law moment has implications for their theories. Of course, there have been some foundational works of American constitutional theory produced by Thomistic theorists prior to our natural law moment. I don't want to leave a contrary impression. Among the most important that come to mind are Russell Hittinger's book, The First Grace, and some of Robert P. George's work, especially in his book In Defense of Natural Law. Yet Hittinger and George's contributions highlight a second distinctive feature of today's natural law constitutional theorists. They are primarily constitutional theorists, not legal philosophers. They are constitutional theorists who rely on natural law philosophy, whereas Hittinger and George are natural law philosophers who sometimes write about constitutional theory. Now, that might not sound significant, but it certainly can be. While there are exceptions, constitutional theorists tend to be more deeply enmeshed in the specifics of the American constitutional regime than are legal philosophers. And they tend to care more about the application of sound legal philosophy to American legal and social practices. Hittinger and George, for example, are not really concerned with prescribing or defending an approach to constitutional law or adjudication, be it originalist or non-originalist. They've certainly said things about those topics. George has offered brief defenses of originalism on natural law grounds in some of his writings. But as a general matter, both George and Hittinger were far more concerned with more foundational questions of the nature of law that then have implications for constitutional adjudication, as opposed to just directly addressing whether one ought to be originalist or non-originalist, again, with a few exceptions. By contrast, all the natural law constitutional theorists of our natural law moment defend originalist or non-originalist constitutional theories and make arguments that are kind of closer to the ground of American law. And that points to the final distinguishing characteristic of the current group of natural law constitutional theorists. They come in originalist and non-originalist varieties. This is a significant change from earlier natural law constitutional theorists like Jaffe and Arcus, who were fierce critics of originalism. While DiGirolamo and Vermeule continue in the tradition of non-originalist natural law constitutional theorists, it's a remarkable fact that most natural law constitutional theory scholarship being produced today comes from originalists. That's a stark departure from the era in which Robert Bork and Antonin Scalia assailed their natural law critics and defended originalism in terms that bordered on, and sometimes seemed to pass over into, moral relativism. Now, this last observation leads to our second question. What explains the rise of natural law in American constitutional theory at this moment? Since there have always been non-originalist natural law thinkers, as I was just mentioning, what really requires explanation is what happened within originalism that led to this moment where you could have originalist natural law constitutional theorists. What changed since the time of Bork and Scalia that created the possibility of our natural law moment? Certainly some of the reasons are historically contingent. For example, there might have been less interest among scholars and jurists about the interaction of natural law and originalism had originalists remained a small minority within the federal judiciary, as they were when Bork and Scalia were writing in their prime. But because originalism in some form is now arguably the dominant methodology among federal judges, including a majority of the Supreme Court, the need for worked out, rigorous justifications for originalism is more relevant to legal scholarship than ever before. And the rise of originalism within the federal judiciary was, of course, the result of innumerable historical contingencies, some political, some legal. Another, perhaps less obvious historical contingency was the work of two prior generations of natural law theorists, including John Finnis, Hittinger, and George. These scholars revived interest in the natural law tradition within parts of the academy. I should note here that Lee Strang has made a version of this same point in explaining the rise of natural law originalism, so I'm borrowing from him on this point. How these natural law theorists accomplished the revival of natural law theory is a long and complicated story. It's one that, frankly, other scholars are better suited to telling than I am. But without the efforts of these legal philosophers, we can venture to guess that no revival of natural law would be present in constitutional theory today. Indeed, it's a striking fact that three of the legal scholars who work at the intersection of natural law and constitutional theory at our current moment, Jeff Pojanowski, Sharif Girgis, and myself, were all students of Robert George at Princeton. It's hard to imagine that I'd be here talking to you today about natural law constitutional theory had I not been George's student, and I suspect the same is true of Pojanowski and Girgis. But there have also been theoretical developments that help explain why we now have a natural law moment that spans the originalist, non-originalist divide. Strang again has offered helpful insights on this score, but I would suggest that the most important theoretical development was that originalist scholars started embracing the need to make moral truth claims in constitutional theory, at least insofar as the theorist is offering a theory of constitutional adjudication. As I said, most constitutional theories propose a methodology for resolving constitutional disputes and offer a justification for why judges ought to adopt that methodology. For example, Strauss argues that, by and large, judges should resolve constitutional disputes through a common law, precedent-based methodology, and he offers justifications for adopting that methodology. A constitutional theory that proposes a methodology of constitutional adjudication therefore has to explain why judges ought to adopt that methodology. From the 1970s through the mid-1990s, originalists largely attempted to justify their methodologies without resorting to contested moral truth claims. Bork, for example, emphasized the importance of moral neutrality in constitutional adjudication and refused to provide a worked-out moral argument for originalism, arguing instead that originalism was the methodology required by our constitutional history and traditions. Why we should be bound by our constitutional history and traditions was never really explained. When pressed on the need for a moral argument justifying originalism, Bork fell back onto claims that seemed to cross over, as I said earlier, into moral relativism, such as his statement when writing about, quote, fundamental values, that, quote, there is no way of deciding these matters other than by reference to some system of moral or ethical values that has no objective or intrinsic validity of its own, and about which men can and do differ, unquote. Bork's approach reflected a broader moral skepticism among early originalists. Now, to be clear, I'm not claiming that Bork or these early originalists did not believe in moral realism, that they didn't believe that there were objective moral truths. In fact, Bork and other early originalists made clear in other writings that they did believe that there were objective moral truths. My point, rather, is that they were very wary of making moral truth claims in constitutional theory, largely in reaction against what they perceived, correctly in my view, to be the abuse of judicial power by the Warren and Burger courts in imposing controversial moral views through constitutional law. But the ostensible moral neutrality proposed by the early originalists could not endure. Justifying a constitutional methodology requires arguing that judges ought to employ that methodology, which requires making a moral argument that the methodology is better than its competitors. And we can only know the comparative moral soundness of competing methodologies by reference to some standard of moral evaluation. And for a theorist to assert that there is a standard of moral evaluation that other people ought to accept is to assert that the moral standard applies to them as much as it applies to the theorist, which ultimately means, though some further argumentation would be required to show this, that the theorist is asserting that the moral standard is true. Therefore, attempting to justify constitutional theories based on social facts or with thin, uncontroversial moral claims will not succeed, since moral truth claims are both necessary to constitutional theory and will inevitably be controversial. Thus, if originalists wanted judges to accept their view and reject competitor theories, they had to provide a moral argument based on contested moral truth claims. Now, that doesn't necessarily mean that originalist judges have to make case-by-case moral judgments when adjudicating disputes. And indeed, in my view, originalism does not require that kind of case-by-case application of moral reasoning in adjudicating disputes. But it does mean that originalists necessarily have to make moral judgments in choosing originalism over competing methodologies. The gradual realization of this theoretical point coincided with the rise of originalism within the federal judiciary that I noted earlier. To borrow loosely from a point Keith Whittington made in a related context, and here I've altered his quote a little bit. Quote, as originalists found themselves in the majority, they needed to develop a governing philosophy appropriate to guide majority opinions, not just to fill dissents, unquote. It's one thing to be a backbencher. It's another thing to actually be writing majority opinions. And that meant that the inadequate moral justifications of the 1970s and the 1980s had to give way to stronger justifications. This confluence of theoretical and historical reasons might explain why the generation of originalists who began writing towards the end of the 1990s and into the early 2000s rejected the ostensible moral neutrality or even relativism of the older originalist theories. Thus, Whittington's 1999 book, Constitutional Interpretation, offered a moral defense of originalism based on popular sovereignty. And that was followed by works like Randy Barnett's Restoring the Lost Constitution that likewise grounded originalism in moral truth claims. Indeed, it's often forgotten that Barnett relied on Aquinas for part of his argument. This embrace of moral truth claims by originalists opened the door to moral justifications rooted in the natural law tradition. And this occurred around the same time that new generations of future constitutional theorists were being formed in the natural law tradition by scholars like Finnis, George, and Hittinger. The result was that, whereas Bork famously argued against natural law critics of originalism by asserting the ostensible moral neutrality of originalism, some of his successors argued for originalism based on natural law. So we have a natural law moment in constitutional theory that's distinctive and that emerged at this time for various theoretical and historical reasons, but why should we care? What are the implications of the natural law moment for constitutional theory? In this final section of my remarks, I'll highlight 3 implications of our natural law moment. I should preface what I'm going to say by noting that there are other potential implications that I do not discuss here, such as the possible role of natural law in situations of legal underdeterminacy. This is a point that actually Professor Vermeule has mostly focused on in his writings. It's just an implication that I'm not going to focus on in my remarks here. It's also worth noting that the extent to which each implication applies might vary with the type of natural law constitutional theory at issue. But let's just get started. So first, natural law constitutional theories have a smaller gap between their theories of law and their theories of adjudication than other constitutional theories tend to have. That is to say, once you've bought into the natural law way of thinking about what law is and how to identify the law, there are normative implications for how you should think about methodologies for resolving constitutional disputes. In recent years, several scholars, both originalist and non-originalist, have argued that constitutional theorists should focus more on theories of law rather than on theories of adjudication. They seek to establish a consensus around the law of our Constitution, leaving for another day normative questions like whether we ought to obey the Constitution and how we ought to resolve disputes under the Constitution. Mitch Berman, Will Bode, Steve Sachs are all representatives of this trend in constitutional theory, sometimes called the positive turn. And it's not surprising that these scholars are all legal positivists of the Hartian or quasi-Hartian variety. Because Hartian legal positivism defines what law is and identifies the law of a jurisdiction according to social facts, it might, if legal positivism is the right way to think about law, be possible to cleanly separate the question of what the law of our Constitution is from the normative questions involved in constitutional adjudication. What the law of our Constitution is would, in a sense, be a descriptive matter, whereas how we should adjudicate constitutional disputes would be a normative question. But if we instead adopt the Thomistic understanding of law, normative evaluation is built into identification of what the law is, since the focal meaning of law requires that law be an ordinance of reason directed toward the common good and that be promulgated by a legitimate authority. If one concludes, for example, that the original meaning of the Constitution is the law in the fullest sense of that term, it follows that we have a prima facie moral obligation to obey it, since doing so would be good for us both in terms of the law's content, since we must have concluded that it is oriented towards the common good, and in terms of sustaining the authority of its author, since we must have concluded that this was a legitimate authority. Thus, there cannot be a total separation between identifying what the law of our Constitution is and normative questions related to constitutional adjudication. The gap between a natural law theory of the Constitution's legality is closely linked with a natural law theory of constitutional adjudication. So one might see natural law constitutional theorists as mounting a counter-argument of sort to the so-called positive turn in constitutional theory. Indeed, Pojanowski and Walsh's Enduring Originalism article took the positive turn as its jumping-off point, criticizing Bode and Sachs for their attempt to divorce law evaluation from law identification. A second implication of our natural law moment in constitutional theory is related to the first implication, and it has to do with a long-running debate among theorists about the extent to which constitutional theory is unavoidably interdisciplinary. Bork once mocked the idea that constitutional theory required, quote, settling the ultimate questions of the basis of political obligation, the merits of contractarianism, rule or act utilitarianism, the nature of the just society, and the like, end quote. He thought constitutional theory could be largely separated from the domains of philosophy and other disciplines and confined to more mundane and technical lawyers' work. In this, Bork represented a persistent strain of constitutional theory that proposes a division of labor between lawyers who handle constitutional adjudication and scholars from other disciplines who handle abstract questions of morality. On the other side, you have theorists like Professor Fallon, Richard Fallon here, who has argued that constitutional theory is inherently interdisciplinary and, quote, cannot be understood except through an approach that links legal, philosophical, and political scientific inquiries, unquote. Fallon urges us to venture the risk of going beyond our training as lawyers to integrate other fields into our discussions of constitutional theory. In this long-running debate, natural law constitutional theorists and scholars like Fallon are on the same side, though perhaps for different reasons, given that Fallon's a legal positivist. If we see constitutional theory through the lens of the natural law tradition, we cannot adjudicate constitutional disputes without resolving antecedent questions of political morality. For instance, we need to know whether the Constitution furthers the common good, and that requires knowing what the common good is, which requires knowing something about who the human person is, and how we flourish as the distinctive kinds of beings that we are. Or to take another example, we need to know whether the Constitution was promulgated by a legitimate authority, and that requires knowing what makes an authority legitimate, which means investigating why we need authority and the relationship between authority and human flourishing. So constitutional theory cannot be neatly separated from deep questions of moral and political philosophy in the natural law conception. Many constitutional theorists outside the natural law tradition might agree at a high level of generality with what I just said. But I want to push further and say that natural law constitutional theory widens the scope of inquiry even more than other constitutional theories tend to do. Because the natural law tradition situates positive law within a broader understanding of the human good, it calls into service disciplines that American constitutional theorists have generally overlooked. For example, in proposing various theories of constitutional legitimacy, constitutional theorists have almost entirely ignored the role of emotional or affective attachments to our Constitution, focusing almost exclusively on the best arguments made in favor of one theory or another. But while Aquinas wrote a treatise on law, he also wrote a treatise on the passions. And the two are interlinked because, as Aquinas argued, human beings develop habits or dispositions, which can either be vices or virtues, only when their reason and emotions are pointed in the same direction. The alignment of reason, emotion, and will is necessary to develop a stable habitus, a stable disposition or habit. So why does this matter? If one of the tasks of constitutional theory is to develop a theory of constitutional legitimacy that conduces to the stability and acceptance of the Constitution over time, and many constitutional theorists across the jurisprudential and political spectrums believe that that is one of their main tasks, then it needs to be a theory that inculcates in the people a habit or disposition in favor of obedience to the Constitution. And they won't develop that disposition if the theory of legitimacy proposed ignores the traditions, rituals, symbols, concepts, and other practices that align the people's passions with the reasons for obeying the Constitution. Constitutional theory thus has to take into account insights from the science and philosophy of emotion. To take just one example of the way in which natural law constitutional theory broadens rather than constricts our field of inquiry. Now, as Fallon has observed, this interdisciplinary approach to constitutional theory is uncomfortable for many legal scholars, since it forces us to venture into domains in which we are not experts. And I'm not arguing that a judge or practicing lawyer cannot do their jobs well without resolving deeply complex questions of political philosophy. But I am arguing with Fallon that the field of constitutional theory does require exploring such topics, even at the risk of appearing foolish by overstepping our expertise. It is our responsibility to seek out the best scholarship in other disciplines to inform ourselves as best we can to the extent necessary to do constitutional theory well. And that leads to the final implication of our natural law moment that I want to highlight here, and I'll close my remarks with this. Natural law constitutional theorists seek to bring the rest of the field into conversation with authors and sources that have too long been neglected in American constitutional theory scholarship. Most obviously, natural law constitutional theorists rely heavily on Aristotle and Aquinas. While both figures, especially Aristotle, have played a role in constitutional theory scholarship over the last several decades, such as in the virtue ethics work of Larry Solem, natural law constitutional theorists explore the writings of Aristotle and Aquinas in far greater depth than has been typical of American constitutional theorists. But that's just one example, an obvious example. There are many profound and consequential figures in the natural law tradition whose work has been almost entirely overlooked by American constitutional theorists. My own scholarship, for example, has attempted to bring constitutional theorists into conversation with thinkers like Cicero, Cajetan, Suarez, Bellarmine, Rahman, and Simone, all of whom have, up until now, played virtually no role in American constitutional theory scholarship. My respectful suggestion is that these giant figures of the natural law tradition have much to teach us about constitutional theory, and their time of being neglected should come to an end. In this way, our natural law moment in constitutional theory holds out the exciting prospect of the discovery, or we might say the rediscovery, of insights and arguments that have lain dormant for all these many years, patiently waiting for us to find them. Thank you.
We're going to take questions, and there's going to be, please wait for the microphone. And we'll go about 15 or 20 minutes we have.
Hi, Professor. I want to express deep admiration for your work. I've read some of your work. I've really enjoyed some of your work and so on. And I want to express all deference as a student and so on, but I want to push back ever so slightly. I felt that one of the most consequential moments in your remarks was when you said you wanted to push further in the scope of constitutional inquiry into broader questions of human good and the common good. And so you said that, again, natural law looks for, and I'm familiar with the work of Finnis looks for, 7 fundamental human goods, and Fuller looks for 8 criteria of just law, and Aquinas looks for, 4 criteria of the good, and so on. And again, Vermeulen looks for, conditions that promote human flourishing and so on. But it seems to me that that's in tension with the originalist claim that the meaning of constitutional values are historically bound and determined by the original public meaning at the founding, which has a kind of historically fenced-in value. And so there is some room for disagreement. There is still kind of a procedural scope. There is room for disagreement, but there's a historically bound scope of inquiry there. And so how do you reconcile or accommodate those tensions? Because it seems that while there may be some natural law claims implicit within Locke or Montesquieu or other thinkers who were relevant to the original public meaning at the time of the founding, it seems to me very naively here that open-ended inquiries into the natural law goods may be off the table.
Well, thanks for that question and that challenge. I appreciate it. So I think that the first thing to say is my argument for grounding originalism in the natural law tradition does not rely on the notion that the founders were themselves Thomists, right, and were constructing the Constitution based on necessarily a sound understanding of natural law theory. They might or might not have. That's in terms of their own subjective views of this. I don't think that matters. I think what matters is objectively assessing whether the content of the Constitution as originally understood accords with the natural law tradition. And if so, then that creates at least a general reason to obey the original meaning of the Constitution if it's been promulgated by a legitimate authority. So it really seems to me that a lot of the debate over originalism and the natural law tradition is about this question of authority. Because if it's the case that the people acting as sovereign are the legitimate lawmaker to promulgate the Constitution, and that's obviously a hugely contestable claim, but if it is the case, then I think it does follow that understanding their commands the way they understood them at the time is necessary to sustain their authority, for their authority to not be undermined by subsequent reinterpretation of the Constitution through judicial or even general political action. And none of that, I think, is contrary to the natural law tradition, because the natural law tradition sets boundaries, moral boundaries, on what kind of constitution can be promulgated by the legitimate authority, but allows for broad discretion within those boundaries as matters of determination, right? But once that determination happens in the natural law tradition, those determinations take on moral significance. So yes, there's nothing in the natural law that requires that we have the separation of powers. But once the Constitution, through the people's legitimate exercise of their authority, sets the separation of powers as the structure of our regime, obedience to that structure, because that structure is not itself contrary to the natural law, takes on moral obligatory force. And so I think the only way to then, if all of that's right, then the only way to get around originalism, as I understand it, would be to instead make the argument that, well, fine, but that doesn't necessarily bind you to a frozen moment in time as to the people's understanding of the Constitution. What if, over time, the people as sovereigns' understanding of their Constitution changes? Isn't that actually respecting the meaning of, the authority, rather, of the people as sovereign? And this is basically the view of someone like Bruce Ackerman or Jack Balkin, who take this view. They are popular sovereignty theorists, and they do think it's important for the interpretation of the Constitution to align with how the people themselves understand it. But they think that as the people's views change, so can the Constitution. And there I think you just have to look at Article 5 and the people's explicit renunciation as a matter of determination of changing constitutional law through anything other than an established procedure. And unless you're going to argue that subsequent acts by the popular sovereign have abolished Article 5 or amended it effectively, then I don't see how you get to that version of popular sovereignty constitutionalism. So that's kind of the full, in brief, a full response. But the core of the point, just to kind of boil this down, the core of the point is that the natural law simply sets outer boundaries in constitution making and allows for the legitimate lawmaker to set as a matter of determination how to structure that regime. And once that has happened, that structure takes on moral significance and obligatory force in the natural law tradition. And it seems to me that if we're going to respect that obligatory force, it has to be in accordance with how those provisions were originally understood by the popular sovereign.
Hi, thank you very much. I was wondering the extent to which you think the natural law moment is attributable to a broader Catholic legal thought movement. I'm thinking of the current composition of the Supreme Court. You cited a couple Catholic Notre Dame law professors. And if so, why do you think the Catholic legal tradition is speaking to our current moment?
Yeah, it's a great question, and the title of my lecture, "The Natural Law Moment in Constitutional Theory," there is some overlap there, right, with Father Richard John Newhouse's idea of the Catholic moment, and so yeah, there's very much that kind of resonance as you're saying. I do think that this revival of Catholic intellectual thought during the 80s and 90s and early 2000s plays a direct role in the revival of natural law theory within the academy. But I do want to point out that it's not an exclusively Catholic phenomenon, right? There were many non-Catholic natural law theorists, including in that formative period, who were part of this revival of natural law theory within the academy. And there'd be an interesting analysis to be done, which I have not done, but there'd be an interesting analysis to be done about kind of the parallel influence of Strauss on the revival of natural law theory. Because if you think about Jaffa and Arcus, they have a very Straussian, I mean obviously Jaffa, but Arcus as well, very Straussian there are very Straussian themes to their work. And that strain of natural law theorizing is obviously not Catholic in terms of many of the people who constitute it. And that parallel development of thought within the American Academy, I think has interesting ways in which it enriches the Catholic strain that's happening at the same time.
Thank you so much for this talk, which has inspired 40,000 questions, and I will limit myself to one. But I feel odd because I feel like you've brought out the inner Scalia in me, which I hide as much as I can. But here's the motivation. So I understand the history of originalism to be grounded in the history of the conservative legal movement, and the conservative legal movement was born as a movement of judicial restraint. And originalism is the interpretive method to operationalize judicial restraint. And the overwhelming claim of Bork and Scalia in the early stages of originalism is almost Therian. Unless it's completely clear that the Constitution stands against some act of Congress, Congress gets to act. And so what was motivating that is not, as you were suggesting, a belief that this was the true theory of the Constitution. It was a belief that this operationalized an institutional understanding of the role of courts within the Constitution. This is a good way to cabin courts so that courts don't blow themselves up like the courts did in the lead up to the New Deal confrontation. And I think that's important because as you're describing all the things that fit within what we should understand natural law theory to include, there's a lot of judgment there, and each time you pointed to the judgments that had to be made, I'm thinking, in my Scalia mode, who the hell are judges to be making those judgments? Shouldn't we have a theory that shifts most of those judgments into a plainly democratic process that doesn't try to fancy itself up with words like constitutional theory?
Okay, so I think there's a lot to say in response to that question, which I really appreciate. First, I'll say that I want to emphasize that there's a distinction to be made here between the moral reasoning that goes into justifying originalism and using moral reasoning in deciding individual cases, right? And there are a lot of originalists who would say, and I count myself among them, you have to engage in these kind of difficult philosophical questions on the first point, justifying originalism. But once you justify originalism itself, it does not necessarily require case-by-case moral evaluation. And if it does, the warrant for it would be the original meaning itself, picking up moral standards that have to be applied as a matter of original meaning, not as a freestanding warrant for you to just go out and start making moral inquiry in any given case. So the first point I would make is I actually don't think that in operation, my understanding of originalism as grounded in natural law would be that different from how Justice Scalia or many of the current members of the Supreme Court would do originalism, right? At least with respect to this issue about moral reasoning coming in. But on the first question, the antecedent issue about whether you need these types of very complicated and abstract moral arguments to justify originalism, I just think that they were just wrong, the early originalists, in thinking you could avoid that. I don't see how you can. Even to say, well, this is just an institutional allocation of authority. We just want to make sure that judges are not intervening too much. Well, what justifies that? What justifies that as your claim for originalism? That presupposes some sort of understanding of what is the right allocation of authority in among the branches in our society, and that itself requires some sort of normative justification, which is ultimately going to require to articulate some moral argument about what's best for that society. And the fact that they didn't really do that, or at least didn't do it very well, in my view, doesn't defeat the need for it. I think they just largely skipped over it. I'll also just very quickly say, I think the relationship between originalism and judicial restraint has changed significantly during that period, right? That, especially as you say, I completely agree with what you said, Professor Alicea, that at the beginning of the conservative legal movement, there was a very Thayerian strain to legal conservatism and to originalism in particular. You see that a lot in like Rehnquist's arguments for some version of, he's not really originalist, but some version of originalism. But that changed a lot, I think, by the 90s and into the early 2000s, where most originalists came to realize that the arguments that they were making for originalism didn't really align with putting the thumb on the scale in the way that Thayerian judicial restraint does, that if you're an originalist, you should really just enforce the original meaning. Now, if enforcing the original meaning itself bakes in some sort of Thayerian standard as a matter of original meaning, that's one thing. But simply adding it in seems to be inconsistent with a lot of the premises of originalism.
Okay, you're first.
Hi, thank you. I wasn't gonna ask my question because I knew that this wasn't a super religious-based talk, but he opened the door for me. So I want to kind of defend Bork a little bit. I mean, I think it's hard to read, Slashing against Gomorrah and not think that he's against moral relativism, but I think in the case of natural law is aiming at kind of Christian values without having those explicitly in front of you, right? But I think kind of the backbone of that is that it can't contradict those values, right? If it's trying to aim at those things, it can't directly contradict those things. So I actually would see Bork as the better natural law theorist for saying that, well, we know from scripture, or we know from however he derives it, maybe it is a natural law way, that if a governing authority is in authority, then they have legitimate authority, right? I think that comes directly from Romans. So I don't see how that would not be a natural law take if you're saying that the natural law moral decision has to come before even choosing originalism. Well, why not just, they're an authority, they're in a legitimate authority, thus we have to go by this originalism, right? Because the people that are in authority, or the thing that is in authority, is the Constitution.
Well, I think that it kind of just begs the question, right? Because the whole question is whether we ought to obey the Constitution, and if so, why? We can't just stipulate that. And if the argument is, well, it is the current governing authority, and that by itself justifies it, as you said, in sort of a reference to scripture, well, that is, I think, very difficult to square with the Catholic intellectual tradition if you're going to rely explicitly on kind of a religious sort of basis, including Aquinas himself, right, who justifies revolution in certain very limited circumstances. The mere fact that you have a current government that is exercising authority does not mean that authority retains moral legitimacy no matter what horrible things it did to come to power or does while in power, right? So there has to be some backstop to that, and that means that there also has to be some affirmative argument for the moral legitimacy of the Constitution to justify our obedience to it. But I want to just say one thing in strong affirmation of what you said, which is your, I think, laudatory desire to defend Bork from me, because I myself have been deeply influenced by Robert Bork and by his writings. I would probably not be writing about originalism today had I not encountered Robert Bork's work while in college. And so I want to make clear that despite my criticisms of Bork's justifications for originalism, none of that is to diminish him as a giant figure within the history of originalism and legal scholarship. It's simply to say that even giants sometimes make mistakes.
I think I'm going to claim the last question since we're out of time. If I understand the argument at the 40,000-foot level, it's that we need a natural law justification, a moral justification, and for you, a natural law justification of originalism. And that's necessary to ground it, but then the judges applying originalism don't have to engage in that moral.
Not necessarily.
Not necessarily. Okay, but so does the natural, but you haven't told us, so by my count, when I wrote it down once, there are about 12 different versions of originalism over the years, and dozens and dozens of different versions that get practiced by the Supreme Court over the years. None
Within a given term.
in the same term, right? Yeah. So I'm just wondering, so you've got your natural law justification of originalism, but which stripe of originalism gets, a serious question.
Yeah, no, it is a serious question.
Which stripe of originalism gets justified, or would it include Lessig originalism? Would it include original intent originalism? Do you get to choose among the whole menu of 12? Or is it more determinate than that?
Right, so I have studiously avoided wading into those debates in my own work because my goal has been to try to just justify originalism in principle from the natural law tradition. I will just tell you that my own kind of tentative view on this is that once you take on board the Thomistic understanding of natural law and what law is, it tends to lead you more towards an original intent approach. And Richard Eakins' work, I think, is really important in this regard, since Richard himself comes from the natural law tradition. I also think it probably leads you more towards an original methods, original law, originalism approach methodologically. So I actually think that despite my implicit criticisms today of Professor Sachs's approach to originalism, I actually think operationally, his focus on the original methods of interpreting the Constitution is exactly right, even from my perspective as a natural law originalist, yes.
And does that mean that implicitly or silently there that it rules out or disfavors public meaning originalism?
I think that the opposition between these two, as Eakins has pointed out, is overstated, because what a plausible original intent originalism would be saying is that understanding the need for an intention and a lawmaker is necessary for a coherent understanding of law. That doesn't necessarily mean that in terms of the evidence that you use to figure out what that intent is, that joint intention is, that it's radically different from what the public meaning originalists would be doing. So I think just one reason I've stayed out of these debates is I think that in general they're overstated in terms of their significance, in terms of concrete outcomes. I do think they're important conceptually, and I think that Eakins and others have done a good job of showing that certainly from a natural law point of view, it's more coherent to think in terms of joint intention.
Well, thanks so much.
Thank you.